Hi, everyone. Harry here to talk about Donald Trump's ridiculous counterclaim against E. Jean Carroll. All right, you recall that E. Jean Carroll had a definitive victory under New York law in an initial defamation sexual assault action. And you may recall it was incidental because it didn't matter under New York law, but there was one juror, it seems, who wasn't, they didn't really keep pushing because it didn't matter, but he wasn't willing to say that Trump had actually raped E. Jean Carroll in the dressing room of the department store. But under the law of defamation and sexual assault and what it was about, it didn't matter. So they moved on to the other theory. And continued. Okay, so on that basis that a jury did not find unanimously, and it was, I think, nearly, but they didn't find unanimously, Trump has counterclaimed in the lawsuit against E. Jean Carroll, saying this shows somehow that her allegations of rape, as opposed to sexual assault, as opposed to defamation, but the allegations of rape were false, and therefore she defamed him. And he points to most statements that he's pointing to are outside the statute of limitations, but there was one in the wake of the trial where someone said, "Oh, but they didn't totally find, not the jury didn't unanimously find that he raped you," and she said, "Oh yes he did. Oh yes he did." Now the idea that one juror not agreeing would make a claim false is not just, fanciful and without any legal basis, but if you think about it for a moment, it would like set the legal system, topsy-turvy, that the failure to decide somehow equates to a decision that something, did or didn't happen. I would think even if they unanimously rejected it as a basis for going forward, it wouldn't be a finding. And the whole thing just, wasn't really even at issue in New York law. So you can expect this, I think, to be dismissed in fairly short order, mainly because he hasn't done anything to show that the allegation of rape is false, except that one juror didn't believe it. That doesn't show something's false for purposes of the law. And then you would get to the whole rest of did she make this false statement with actual malice and et cetera, all the things we know. So, it's another kind of political stunt and he can use to sort of parade around and claim some victory that he didn't have. It's actually a little bit of a preview of what would happen in the event that the Mar-a-Lago case, for example, there's a ardent pro-Trumper who holds out and doesn't vote to convict. He would absolutely tout that as having won the case, and in the political sphere, even though that it doesn't even get out of, it's a non-starter in the legal one. So there you have it, a counterclaim on the still existing defamation claim that she falsely and maliciously accused him of rape. I think that when she will then file a motion to dismiss, saying, he hasn't, even if everything you took was this is how the law would put it, even if all the allegations were accurate, it wouldn't show falsity. And therefore, it doesn't get out of the box. So we'll see if that's how it works. But I think you can lay pretty good odds that this is a counterclaim that is going nowhere. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.